Any mention?
Okay, please, Lordship. Lordship, I beg to mention item number 11, Your Lordship. Item number 11. Here for the petitioner.
Yes. What you want? Just tell us.
Yes, let this matter may come up after puja, Your Lordship. We are seeking adjournment, Lordship.
No
objection, Your Lordship.
11 on by Mr. P.T. Sangma, Learned Counsel appearing on the petition. List after 2 weeks. Yes.
Lordship, this similar prayer for item number 15. This is regarding POCSO, which this similar matter is pending. The teaching bed.
Item 15, make it 3 weeks.
15, 1-5, Lordship.
Yes.
Yes, Lordship. Much less, Lordship.
My lord, I also beg to mention item number 16, my lord. I'm the petitioner, my lord. I have informed my friend also. Yes. Let it come up after 2 weeks, my lord, after the puja.
16 also.
My lord.
Where's the volume? On prayer of Mr. Learned Counsel appearing for the petition. List after 2 weeks. Yes.
Obliged.
Lordship, I beg to make a mention of item number 8. Let this matter come up after 2 weeks, Lordship.
Item number 8.
Number 8.
Who is the other side? District Council?
Your Lordship, I appear for respondent number 4.
Yes, Mr. Any objection to the prayer?
No objection.
No objection, Your Lordship. In fact, the matter does not survive anymore.
Is it? Is it correct?
This is a praying for time, Your Lordship, 2 weeks, and after 2 weeks we can clarify what is the position.
Just say on the prayer of the prayer made on behalf of the petitioner. Not objected to by the Learned Counsel appearing for the respondents. This is met after 2 weeks. Yes.
Obliged.
May I please, Your Lordship? Lordship, I beg to make a mention of item number 13, 1-3.
Yes.
Lordship, in the last hearing, we were allowed to file an additional affidavit, just praying for some more time.
No objection. Has it been recorded that
Yes, Your Lordship.
that you have been given permitted
Yes,
to file?
yes, Your Lordship.
Okay. Yes. Let's give your name, please.
G. Rana.
Learned Counsel appearing for the petitioner. Please for and granted further 2 weeks time for filing. And filing an additional affidavit in terms of the filing the additional affidavit in terms of the order of this court.
Number
Yes.
5.
List according.
Highly obliged.
Please, Lordship. Lordship, I beg to make a mention of item 5.
5.
Lordship, I pray that the matter may come up after vacation, Your Lordship.
This 2016 matter.
Yes, madam. Relating to the home guards who were appointed
Lordship, in
in
this
the
matter, we have to file one undertaking, Your Lordship. On the last occasion, Your Lordship, the deponent had come, Your Lordship, but there are some...
This is the case where common order was passed in 3 writ
Lordship,
petitions.
Yes,
Lordship.
And subsequently some orders were recalled, isn't it?
Yes, Your Lordship.
Yes.
No objection, madam.
Just same thing, just a petitioner prayer, not object to the respondent. List after 2 weeks. Yes.
Highly obliged, Lordship.
Your Lordship,
Yes.
I wish to mention the item 6 and 7, Your Lordship.
Item 6 and 7.
6 and 7. In this case, Your Lordship, I supposed to file my bullet point. And yesterday in the evening, petitioner has given me this their points and state not yet given. So for that day, maybe, Your Lordship.
What is to be given to you?
This bullet point they have filed, Your Lordship. Petitioner has given to me yesterday in the evening, and state whatsoever given, they are not yet given.
Oh,
to
that
the
is the
copy.
matter where this petitioner in the state has filed written argument, isn't it?
Written with the bullet point given.
The
So
order was passed to
It-
supply you copies. So they have not supplied you. Yes.
No,
yesterday in the evening given.
Yesterday.
Yesterday in the evening they given, and then state
Oh, you
not
knew
yet given.
yesterday? How long you knew it?
It will come after.
After 2 weeks.
Lordship.
Why it was given so late? Authorization is complete, isn't it, Ramesh?
So, Your Lordship, the state is not given yet.
The problem is that you see, like, if there is a,
It will be submitted, my lords.
if there is a, what is, anyway, the court forgets everything, you see, if there is a gap in between. Anyway, just say, Mr. R. Devenant, Learned Counsel, applying for the respondent number
567.
567, submits that the copy of the written gist of argument filed on behalf of the copies, copies are filed on behalf of the copies of the written arguments of the petitioner as well as the state respondent were supplied to him only yesterday, and he requires some time to go through the same. He therefore prays that matter may be adjourned. Matter may be adjourned for 2 weeks. Just a prayer allowed. List after 2 weeks.
Grateful, yeah.
Yes,
6 and 7 are connected, Matter, Your Lordship.
6 and 7.
6 and 7.
See, both the matters were 6 and 7.
Yes, my lords. 6 and
Yes.
7.
Much obliged.
Daily cause list, item number 1. Sorry, supplementary cause list. Supplementary cause list.
Yes,
Please, Lordship. Lordship,
Lordship, I'm appearing here.
this is a petition, my lord, for quashing of criminal proceedings.
courtroom is very noisy, Mr. Rizal. It becomes,
I agree, my lord.
it's not only the microphone, the becomes a problem. Very difficult.
My lord.
Yes, please.
My lord, this is a petition, my lord, for quashing of criminal proceedings. The exact similar kind of case, my lord, between the same parties had come up before, my lord, about a week back. If Lordship kindly recalls, petitioner, my lord, is married to respondent number 3. They were married in 1995, my lord, 30 years back. They have 2 children from that marriage, my lord. In addition to those 2 children, unfortunately, my lord, there has been constant dispute and litigation between the parties. If Lordship kindly looks at page 4 of the petition.
This is a petition by the same parties.
Same party. The same
That is in
husband.
relation to another case. This is in relation to.
Yes, my lord. That was another criminal case ongoing. This is another criminal case. Here also, my lord, if Lordship looks at the FIR, that is at page 29.
How many criminal cases were there against you?
My lord, there were 4 ongoing cases. 3 against me, 1 against my wife. 2 are compoundable, my lord. They are being compounded. 2, my lord, we have come before this
They are
court.
being compounded. They are already compounded.
They are in the process of being compounded. They are in the process. So FIR is there, my lord. If Lordship chooses, I can read the FIR.
Page 29.
Page 29. FIR against my husband, so and so.
Anyway, if it is from that same compromise,
My lord,
then we'll just issue notice. Then.
My lord, that's all. That's all.
Yes, Mr.
Yes.
Mr. General, Counsel, appearing for the. Your first page says appellant. The second page says petitioner. The very first page of your petition. Anyway,
I apologize, my lord.
anyway so, Mr. General Learned Counsel. Petitioner issue notice returnable in 3 weeks. Mr. Sangupta Learned additional senior GA or additional PP. Original PP, isn't it? Yes.
Yes.
Appears for respondent 1 2. Petitioner shall take steps for service of notice upon the respondent number 3 within 2 days. List after 3 weeks.
Grateful, Your Honor.
Item number 3.
See. Yes.
Mr. Shahriyasu is the main respondent, my lord.
Where is he? You filed this petition by invoking what provision? Now this is the problem. You see, this matter has been heard how many times?
It's been nearly a year, more than a year, lordship.
See,
This
see,
one I
see.
have invoked in the chapter.
Just read that provision. Take out the High Court rules and read that provision. And just tell us whether it applies to this case or not. Mr. P.T. Sangma is a problem. It's a real problem. This matter has been heard time and again, has been adjourned in many times, just to afford you a chance. In spite of that, you see, it seems like this. Just see. Tell us what is the provision about. You have a High Court rule. You do not have. Please, madam, if you have, just supply him a copy of High Court rules. Do you have a copy of High Court rules here? Oh yes, just give it. And read it. Yes, Mr. Sangneshwar, this matter has been argued many times. See, no one has at least pointed out and what provision has been invoked here. Now, when it is nobody's case that the Limitation Act is applicable, can we ourselves convert this petition, even if we find that there is a wrong quotation, can we convert it petition into petition under Section 5 of the Limitation Act and pass some order to ensure that substantial justice has been done? Can we do it? It should have been pointed out. You also have not pointed out.
Yes, last time I.
Cannot be invoked to condone the delay. The application as such stands rejected. Now give a paragraph that since it is not the case of any of the parties herein that provision of Limitation Act 19. What is the year? Limitation Act of which year?
63, lordship.
Okay, 1963 is applicable in writ petition, comma, the rejection of this rejection of the instant application shall will not pose any bar to consideration of the restoration application filed by the applicant. Stop. The registry is therefore directed to diarize the restoration application filed by the application and list it for consideration by the court. The question of delay and laches in preferring the restoration application. Question of delay and laches, comma, if any, comma, in preferring the restoration application. Shall remain open for consideration at the time of consideration of the restoration petition. In spite of rejecting your application, the court is doing substantial justice. But then you should be careful, Mr. Sama. Yes, there may be correction here, there, no? It's all right.
Daily cause list, item number 1.
We have not recorded Mr. Sangreshu. The document is cited by you because we think it is not required. This court was, like confusion what to be done yesterday. After progressing on next, we cannot suo motu restore this, convert it to section 5 also, because admittedly limitation act is not applicable. That was a difficulty. And you should have pointed out. That was expected from you.
Lordship, we played no role actually, honestly, my lord.
It was about pointing out the provision. Nothing else. It's all right.
Apply, Lordship.
Yes.
My lords, I am for the petitioner in the said matter.
Well, madam, you are not visible. I do not know.
My lords, my camera is on.
Yes, okay, anyway, just say we can hear you. Please tell us what you want.
Yes, my lords. So I am for the petitioner in the matter. If you can just allow me, I'll give short facts of the matter. This is a matter where accused number 1, who was then bank manager of Meghalaya Route.
Without having a picture of you becomes very difficult.
I'm so sorry, my lords.
It is
I'm
like
trying. My camera.
Telephone call. That's a problem.
My camera is absolutely on, my lords.
Probably we have a problem here. That is the problem. You see, probably on the last occasion also we had the same difficulty.
I apologize.
You see, the problem is that like, your apology will not solve the problem. The thing is that
I understand, my lords.
You see,
I understand.
until unless we see your expression, then we will not be convinced. So that is what the problem is. When can you make yourself available here, madam?
My lords, whenever you give a date next, I'll be there, my lords.
So it has to be only after vacation then. When your matter is coming up, Mr. Khalila? Your matter before the trial court?
10 in.
So when we are opening again? We'll have it on then 6th of October, I think it is better. 6th October will be reopening, isn't it? Yes, we'll have it on 6th October.
My lord, 6th is a problem for me. If we can have
then
it
you choose between 6, 7, 8.
Ma'am, my lords, 8th will be fine.
Okay. Just say. Anyway, just say on prayer meet. It will be all right, Dr. Mojika, for you. 8th. Yes, you'll be here. Yes.
My lords, I'm so sorry. 7th, can it be made 7th? I'm really sorry.
Yes, 7th also is okay. All right.
Much obliged, my lord.
Just say as agreed to the Learned Council with parties, list this matter on 7th October. Huh? Yes.
Item number 2.
Yes, sir. Yeah. Now, decision referred by you and the petitioner, more or less same. These three decisions only you need to consider.
One more is there. I'll give it.
See, we do not. So far, this thing is that okay, you have referred to SLR to
Yes.
give understand the
What was the law prevailing?
and then either consulting and UHL power.
My lord, if I may, my lord, it may be passed over for a while. Senior counsel, he's on
Let
legs.
him come. We are not finishing it. Let him come. Let him come. You are there. You are a able man. You can tackle with this situation.
My
There
lord.
is no problem.
Your Lordship, while referring to the Hyder constructions, the point which came out was this, that when the interest is clubbed with the principal amount and over that post-award interest is awarded, it's not the case of interest upon interest or a compound interest. That paragraph 31 which I have referred to in the case of Hyder Consultings. Now we come to the judgment of my friend on which heavy reliance is placed, that is Morgan Security. It's at page 139.
Modern security is where it is.
Page 139 of the compilation of my friend's judgments.
There is only one compilation submitted by you, Mr. Khera.
Yes.
My lord.
Yes.
139.
Just a minute. Yes, please.
My submission is this, that this case is absolutely not applicable in the case in hand.
Have you stated it in your written notes, Mr. Jindal?
Yes, Lordship. I have stated.
This will not. The proposition of this will not apply to your case.
Will not apply. But I have no dispute with regard to the proposition laid down under this judgment. But the facts of both the cases are absolutely different. Now, Your Lordship, come to page 143. This appeal arises from a judgment dated 26
Mr. Jindal, we will have to stop you. Rise for division bench will come back because I think you will take some time. You will take some time, isn't it?
half an hour.
So definitely. Then we have to rise and then you come back. The court will go for division bench, then it will come
And
back.
thereafter,
Thereafter again, of course, we do not know depending on
how long
what
it will take.
things are uncertain, not only for you, for court also.
Becoming little.
We do not know so long, you see, like it is streamlined, then it will be something like that. And the problem is due to some unavoidable circumstances because many cases are fixed by putting date. So even if something is felt to be done, that cannot be executed. So long.
Of course, division bench are,
Once a matter
division
is-
benches are kept in the second half. Then, I mean,
that
we
is-
also do not know what time.
That is for the bar to make decisions. This court cannot help you in this. With this is you are in a better situated place to, give your views. Okay.
Obliged, man.
Item number 4.
Please, Your Lordship, before my senior starts, Your Lordship, I beg to make a mention part of the hearing this item number 3 and 4.
This is not a mentioning hour, isn't it?
Yes, Your Lordship.
Is it a mention time?
Well, because I feel that this matter may take some more time, so
Yes, item?
item number 3 and 4, connected matter, the CNJ.
Where there?
Philemon to Nombri, I have informed him also, Your Lordship.
You have informed him?
Yes, Your Lordship. If this matter may come after Puja vacation, Your Lordship.
Item number 2 and 3.
3 and 4. 3 and 4, Your Lordship. Connected matters.
These are old matters.
Old matter, yes, Your Lordship.
These are what, service matters?
No, this seems as a student for seeking for compensation.
Oh, Mr. Philemon Nangri is the special counsel, no?
Yes, special counsel, yes, Your Lordship.
You are the petitioner. And you are the appearer for?
I'm the petitioner in item number 4, Your Lordship.
Okay, we'll just see. Just say on. Where? I'm permitted by. Mr. But then, what about you are appearing only one matter? You are not appearing both the matters.
She's appearing in item number 3, whereas I'm appearing in item number 4.
Number 3, you are also asking for time there?
Yes, Your Lordship.
Okay, just say on both the matters. Just say on prayer made by counsel of the petitioner. List after 2 weeks. Yes. We'll have after 2 weeks.
Yes, sir. And oblige, Your Lordship.
We'll just present this. The next day you point out about it. Yes.
Lordship. I was referring to the judgment of Morgan case, which is heavily relied by my learned friend. Now, that is on page 139 of the compilation.
Yes.
And I'm at page 143. Lordship got it?
Yes.
I was reading para 2.
Yes.
On 27/1/2003, the appellant and the respondent enter into an agreement under which the respondent availed a bill discounting facility agreement. The dues remained unpaid. The appellant issued a notice to the respondent on 10/1/2006 demanding the payment of the principal amount of rupees so and so, which is the date of default, along with an overdue interest. Since the respondent did not pay the amount as demanded, the appellant issued a notice on so and so date invoking the arbitration clause of the agreement. The sole arbitrator rendered an arbitral award in favor of the appellant on 1/3/2003. The award was corrected on 29/4/2013. The decree the claim of the and decreased the claim of the appellant in the amount of rupees 5 crore plus interest at the rate of 20% per annum has been granted from the date of default to the date of notice to the date of award, that is pre-award interest. Your Lordship, next line is very important. And number 3, 18% per annum on the principal amount of rupees 5 crores. Your Lordship, this was a case where the sole arbitrator has awarded the post-award interest only on the principal sum. And we are not having such a case. Now, in my case, Your Lordship,
it's totally distinguishable. It's like from what?
Yes, totally distinguishable. And because of the reason that in this case the sole arbitrator specifically said that principal amount. And in my case, it is the sum awarded or amount awarded, and it is not on the principal sum. The relevant extract of the award is set out below. This is the, Your Honor, operating portion of the award. In view of the finding of the tribunal above, respondent number 2 is liable to pay a sum of rupees 5 crore plus 6 so and so with interest at the rate of 21% till the date of demand notice. After the date of demand notice, that is 10/1/2006, the claimant is entitled to receive interest at the rate of 36% per annum with monthly rests. Further, in terms of the A4 decision in SL Aurora, the claimant is entitled to receive post-award interest at the rate of 18% per annum only on the principal amount. These are the catchword, Your Lordship, in this case. The appellant challenged the arbitral award in a petition under Section 34 before the Delhi High Court, raising objection on the grant of post-award and the pre-award interest. The respondent also filed a petition. The appellant asked that the post-award interest of 18% per annum should be granted on the total sum awarded, inclusive both of principal and the pre-award interest. By a judgment dated 7/2/2019, the single judge of the Delhi High Court dismissed the petition filed by the appellant on the grant of the post-award interest. The single judge held that the arbitrator had, in his discretion, restricted the post-award interest to the principal amount. The question was this, whether the arbitrator can award the post-award interest exercising his discretions. He may refuse also. But in the case which we are dealing now, there is no such similarity.
Now, say supposing in a case where is no such specific restriction.
Yes.
Or say like
award is silent.
Yes. Then what?
Award is silent. Then clause B will be triggered, and claimant will be entitled to 18% per annum. If the award is silent, and there is no dispute on this proposition, Your Lordship. No dispute. And here also I have no dispute. So far the proposition of law laid down by the apex court in Morgan case is concerned. The issue is whether this is applicable under the facts and circumstances of the instant case. My respectful submission before this honorable court is this, that this judgment absolutely does not apply.
But you are not disputing the proposition laid down in Morgan.
Yes.
Isn't it? So
Yes.
the proposition stands.
Proposition
What
stands.
requires for us is that which way you read the award.
Yes.
Isn't it?
Yes.
That is what the crux of the issue.
And if the award is read, we find that the arbitral tribunal has awarded the post-award interest of 12% for the 90 days. And thereafter, if the payment is not made, there is an increase of 2% of interest, subject to the maximum of 18%. Now, here the arbitrator have exercised the discretion by giving them 3 months time, that deposit within 3 months, and if you don't deposit, the rate of interest shall increase.
But then it is simple interest, isn't it?
Lordship?
Simple interest.
Simple interest. And that is simple interest. And here The court has your lordship awarded the executing court has also calculated, or both the parties have calculated on the simple interest basis. The difference is coming.
Only what should be the award? What is the amount?
Amount awarded. He says the amount awarded is the principal amount, which cannot be. Which cannot be.
You say it includes the pre-award.
Yes, awarded amount as per the Hyder construction case is inclusive of the pre-award interest. And when the pre-award interest is clubbed with the principal amount, then it becomes the amount awarded. Amount awarded. Say for example, that award is passed on a particular date. Next date, they make the payment. They make the payment. In that case, they will not make that this is principal, this is the total amount which will be inclusive of pre-award interest. And that is the on the date of award, that is the calculation. If they want to pay the awarded amount, both the things have to be paid together. Am I clear?
That is okay. That is yes. One way you are okay. You are correct. Say supposing if any award is made, which grants them pre-award interest, and the amount is paid on the next day.
Yes.
Then this interest calculated.
Yes.
Will be paid.
It will be paid. So that becomes the amount awarded.
But then if it is not paid on the next day,
if it is not paid,
which way it will be carried?
If it is not paid on the next date, then it will carry the interest. It will carry the interest. That's what your lordship Hyder construction has dealt. That this cannot be said to be an interest upon interest or a compound interest. It is a simple interest. It is a simple interest.
What the executing court say? So
No,
far as the
executing
judgment is concerned.
Morgan.
No, impugned judgment. Judgment
Yes.
which is impugned here.
Yes, lordship.
What does it say?
They say that it is inclusive of the interest.
Where is the finding recorded? What the finding say?
Page 319.
332. It says my lord because of Hyder consulting. अच्छा बोल दीजिए आप ही बोलिए मैं बोलिए आप ही बोलिए मैं हेल्प करूँ आप ही कोशिश कर रहा था
Page
आप ही
3
बोलिए। पेज बता देता हूँ आप पेज भी आप भी बताइए पेज बताने में भी ऑब्जेक्शन है तो क्या करूँ
नहीं पेज आप तो पढ़ने
नहीं
लगे।
पेज तो नहीं पढ़ने में पेज दिखाना चाह रहा था मैं और कोई नहीं आप पढ़िए
Page 319. You said.
Yes, lordship. 319 onward. The order, impugned order is dated 5/2/25.
Yes. And what is the finding part?
Finding part, your lordship will find it.
What will be relevant for us to see?
326 your lordship may see 326
326. Reason and decision of the court.
Yes.
This court shall first address the contention of the judgment debtor as to whether the decree holder, by withdrawing the sum of rupees 32,96,972 deposited by the judgment debtor pursuant to the order dated 27/8/2019, also accepted the fact that the total sum awarded to the decree holder is rupees 1 crore 31 lakhs, as opposed to what has been stated in column 5 of paragraph 5 of the execution petitions. Since 25% of rupees 1 crore 31 lakhs is rupees 32 lakhs 96,972, I am unable to agree to such a submission made on behalf of the judgment debtor, as the same is not supported by any.
What was the contention there? What was their contention that they say that?
There was no contention. The order of the commercial court was this, that decree, that the execution shall remain suspended on payment of 25% of the awarded amount. Now, this was an interim order, conditional order. That and further it was further it was also stated by the commercial court that this will be subject to the outcome of the final judgment. Had their Section 34 application be allowed, I was to return that
Definitely. So
money.
This direction was made at the time when they preferred 34.
34, yes. 34.
Okay, so 25% of that.
And now their contention now is this, that since we have deposited 25% of the principal amount was not the order. And their contention is this, that since we have deposited 25% of the principal amount and the contractor has withdrawn the same, therefore it's a case of waiver and acquiescence. Waiver and acquiescence.
They want to say that he cannot charge further interest.
Further interest. Further.
Because you have accepted it to be a decree.
We are accepting.
Yes.
And my contention is this.
Okay, it's okay.
My contention is this, that this was a conditional order.
Definitely.
Subject to the outcome of the final judgment. Even if they have wrongly calculated, after all, this has to be
Yes, definitely.
done in the final one.
The award will not get altered just because some miscalculation is there.
Yes. The court shall now address the second contention raised by the judgment debtor, that is, interest, either pre-award or post-award, cannot take the color of a principal amount, which is rupees 1,31 lakhs plus. Since the formula adopted as directed by the arbitral award dated 30/12/2006 is that of simple interest and not compound interest, the issue has been decided by the Honorable Apex Court in Hyder Consulting case here. The tribunal, the commercial court has also relied upon this.
Yes.
In Hyder Consulting, UK State of Odisha so and so, the Honorable Apex Court has held that there is no distinction between a sum with interest and a sum without interest. Once the interest is included in the sum for which the award is made, the original sum and the interest component cannot be segregated and be seen independent of each other. The interest component then loses its character of an interest and takes the color of sum for which the award is made. This is the Justice Bobde judgment which is quoted by the commercial court. The decision of the Hyder Consulting UK State of Odisha was upheld by the Honorable Apex Court in UHL Power Company Limited. They have also said
that is what you have said.
that this was rightly decided. And that case is also a case of three judge. By now, the aforesaid has been set at rest by a three-judge bench of this court in Hyder Consulting so and so that has overruled the verdict in SL Aurora, State of Haryana. The majority views that the post-award interest can be granted by an arbitrator on the interest amount awarded. Writing for the majority, both the justice, as his lordship then was, has held in so and so case. In the result, I am of the view that SL Aurora case is wrongly.
You read it out already, so it is
decided. Your lordship, they are commercial court is quoting. Then come to page 320. In view of the settled position of law as laid down in the aforesaid judgment, this court is of the view that the arbitral award is made in respect of a sum which includes the interest, and it cannot be said that what is being granted is interest upon interest. The third contention raised by the judgment debtor is that the principal amount upon which the interest is to be calculated, even in case of a delay in payment, shall remain to be rupees so and so, and upon the deposit of the demand draft on 27/8, the remaining principal amount would be rupees so and so. The interest would be calculated on the principal sum of rupees 1,31 lakhs. However, post the deposit of the demand draft, the interest would be calculated in the remaining principal sum of rupees so and so. To answer this question, this court deems it proper to refer to this judgment. The commercial court has referred to this judgment. I am not bothering your lordship so much on this. Then come to page 331. In view of the settled position of law as laid down in the aforesaid judgment, the contention raised by the judgment therefore is not sustainable. In view of what has been laid down by the Honorable Apex Court in the above decision, this court sees no wrong in calculation submitted by the decree holder. The judgment letter is directed to make payment of the remaining award within 1 month from the date of this order. The order is pronounced in the presence of so and so. So, your lordship, both the parties have given their calculation to the executing court. I will just take your lordship to the calculation which they have given. Come to page 307.
One, just a minute. Yes,
307. Amount awarded, the total claim which are awarded, that comes to 1 crore 31 lakhs 87,889. Now I have no quarrel with this calculation that the total sum against the award was awarded 1 crore 31 lakhs. Then total pre-award interest on claim 1, 2, 6 and 7, it comes to 54 lakhs 14,578.42. No quarrel on this calculation.
Where it is provided 54 lakhs? Okay, second one, yes.
Yes.
Yes, yes.
Total pre-award interest on claim number 1, 2, 6 and 7, it comes to 54 lakhs 14,578.42. Now, then further, lordship, that interest as per...
one second, just tell us.
Interest...
One second, Mr. Jindal. This amount of 54 lakh 14,578 is calculated on what basis? On the basis which the award says...
Interest award, pre-award interest was 12%.
Okay, but up to which date?
Up to the date of award.
Up to the date of award.
Up to the date of award.
So that is why
that is the pre-award interest up to the date of award. Now comes to your lordship.
Now, supposing, let us just for think. Now, say supposing if we had to go by their contention that this interest, pre-award interest will not be included.
Yes.
Then this calculation also could not have been. Then it can only be that the calculation till the date of realization.
Till the date of award. Till the date of award. Okay. So your lordship.
So when they themselves they calculated it.
Separate and only the thing, your lordship, that total pre-awarded interest on claim number 1, 2, 6 and 7, it comes to 54 lakhs.
Yes.
And actual claims awarded is of rupees 1 crore 31 lakhs.
Yes.
If total is made, it comes to around 186, 1 crore 86. Now, the problem starts thereafter. Interest as per award on the principal amount. They counted where from the principal amount comes in. They calculate the post-award interest on the principal amount.
Okay. And that also they calculated till the date they made the deposit of 25%.
12%. 12%.
Then
25%.
And thereafter they reduce that amount.
They reduce that principal amount.
And then make the further.
Then they reduce the further principal amount deposited with the court on 27/8/2009. 32,96,000. Your Lordship, one thing, Your Lordship, on last occasion also I have pointed out.
Now what happens if you make a deposit, say supposing if you make a deposit of 25%
Lordship.
and that is not withdrawn. Then,
So it's not withdrawn that it is at my cost. I have not withdrawn. I have withdrawn after 1 year.
so if it is,
It will remain 1
say
year.
Supposing if it is not withdrawn, then
What is the position? Position is this, Your Lordship,
means
that deposit of the amount, they are required to issue notice to me that we have deposited this amount before the commercial court or before the executing court. When the notice is issued, their liability with regard to that interest, that part of the amount goes. But if no notice is issued, then interest will continue to accrue even on that amount which is deposited as per the interim order. But that was not the case. They deposit in front of me. I had a notice of their deposit. So 32 lakhs which they have deposited, whether I withdraw or I don't withdraw, or I withdraw under protest, whatever may be the case, or I withdraw as per the order of the executing court. Now, one thing, Your Lordship, is again to be seen in their calculation, that 32 lakhs were paid on 27/8/2019. Lordship, got it? Amount deposited with the court on 27/8/2019.
yes.
That is 32 lakhs so and so. Now, this amount must have accrued the interest because the tribunal has awarded the 12% interest, pre-award interest. Now they deposit 25%. Now that deposit is made after 2 years. Let's assume the deposit is made after 2 years. Say, for example, I am to pay Your Lordship.
Yes, we understood. So supposing this deposit is made after 2 years of the award. And definitely the 25% will increase. That is what you want to say.
No, I want to say that the deposit amount must have accrued the interest which they have not taken into consideration. They say we deposit, then principal amount is reduced again.
That is why you calculate interest on the entire award.
Entire award, you may calculate it.
Once your final calculation is based on this,
Yes.
you cannot charge the separate interest for this amount, isn't it?
Yes.
Is it?
No, Your Lordship, they themselves in their calculation would have taken into consideration the interest which has accrued on the interim payment which they have deposited on 27/8. Because the award was passed in 2016 and deposit is made in 2019. That is after 3 years. No, for 3 years, these 32 lakhs remain with him. And I'm to get the interest on this amount. Am I clear, Your Lordship?
Yes, we understood, because you are trying to justify
Lordship.
the calculation of interest
Yes.
on the
Yes.
amount of
Yes.
award.
Yes.
You want to say that this deposit, 25% deposit, would not make the amount of, it will not reduce the amount of award, isn't it?
Yes, Lordship.
It will remain so far as the
Yes.
calculation of interest.
Yes, Lordship. Now, interest as per award on the principal amount after deducting the deposit amount of rupees 36 lakhs. Then 32 lakhs, again they minus from the remaining principal amount. They are going on the basis of the SL or Aurora case.
See, what they are saying that since we have paid the 25%,
Yes.
so that amount stands deducted from the
Principal amount.
Yes, from the
Principal amount.
and whatever calculation
Yes,
interest will be
yes.
charged on the remaining.
Yes. And my contention is this, the 32 lakhs is to be minus from the amount awarded. That is the total amount, which is inclusive of the interest. Sorry. Lordship, may I proceed?
Yes, yes.
Then your Lordship will see that 18% interest is calculated on 98 lakhs. Then total interest, pre-award interest, post-award up to deposition of 25% money plus from deposition till the date of payment 26/7/2015 comes to so much. And according to them, it is 2 crore 98 lakhs which they have paid, deposited. Now, according to me, this is a part payment. And your Lordship will see my calculation.
Subject to what my friend says, my lord, if a lordship will decide the principle and then the issue, then parties can file the based on.
We may not. If it is required, then definitely. But then we will not go
into
beyond
the
what calculation was.
my calculation.
We are in a revisional.
Yes, my lord.
We are
So
in a revisional.
that is what I am praying, my lord.
We will not enter into deep into
calculation aspect, my lord. There may not be requirement to go.
We have a limit of.
That is what I am trying to
We
say.
are just trying to understand what basis.
Yes,
Yours is
that is
318.
the only thing, your
Yours is
Lordship.
page 318.
No, he is at the back foot, I understand. So far the calculation part which they have annexed.
I have not opened my case on that part. And with the front foot and back foot, give me 5 minutes, matter will be over. 10 minutes. I need 10 minutes. 10 minutes only.
You will have your
10 minutes only. Because my friend has been going on and on for last
On and on,
for
you
4
see,
days.
where is the time? You see.
And my meter is also running.
Your meter is running, your boss is with you. Your boss is with you.
Cut short the issue, cut short the issue.
And had they made the payment in the time,
Your calculation is at page 318.
at page 318. Now, your Lordship will find amount awarded, there is no difference.
Yes.
Pre-award interest on because there were two components.
Up to this much is no
Yes,
difference.
yes, it comes 1 crore 86 lakhs. The total claim on the date of award, that is 30th/12/2016, is 1 crore 86 lakh 02,457. Since they have not paid the amount, simple interest to be calculated on this amount of rupees 1 crore 86 lakhs. And they have calculated on the 131 principal amount. Calculation of interest from date of award 30/12 to the date of interim payment on 27/8/2019. That your Lordship calculation is made, and total outstanding on 27/8/2019 is 2 crore 69 lakhs. Amount paid on 27/8/2019 is 32 lakhs. Now this 32 lakhs is deducted by me from the total amount awarded. And what was the amount due on the date when they have made the 25% payment. Now the balance outstanding on 27/8/2019 is 2 crore 36 lakhs 15,956. Interest on from 27/8/2019, that is after they have deposited 32 lakhs, to 16/7/2014, then the calculation comes, your Lordship, to 4 crore 43 lakhs. total amount which is due on 16/7/2014 is 4 crore 43 lakhs plus. Then they have paid the demand draft of 2 crore 98 lakhs. This is the balance which I am claiming. And this was the balance on 16/7/2024.
Now, the difference starts
Yes.
basically from the calculation which you make, which you show the total claim on the date of award on 12 so and so, that is okay. On the date of claim,
Lordship.
that is on the date of award.
Date of
Up to this much is same.
This much is
Okay.
same.
Now thereafter, but then
The post-award interest is to be calculated on 186.
see, probably their calculation, insofar as the amount of claim on the date of award is concerned, that differs, isn't it? No.
That is?
There is a difference.
There is a difference because they are telling that principal amount. From the principal amount, they are counting the interest. And their case is this, that tribunal has awarded interest upon interest, interest upon interest, and compound interest.
No, but then
And I have shown the judgment.
Even if it is, they say sorry, please, you say that their case is that the tribunal has not awarded compound interest.
Their case is this, Your Lordship, that the tribunal cannot award the post-award interest on interest by taking into consideration.
That is where you see, like, you don't know, say, like, which issue you are going. You see, probably that was not the case, isn't it? You see, so far as
in the pleading, this is the case. In the
but then the case which was placed before this court is not with regard to that.
Yes.
What is that? The contention was that whatever is awarded should
Yes.
be specific in the award and should be specifically mentioned in the award.
Yes.
And if it is not, then there cannot be an automatic incorporation or inclusion.
Yes.
And that was sought to be, that argument was sought to be supported by that Morgan case.
Morgan case, I have already shown, Your
Now, the
Lordship.
contention was that this tribunal has the right to give or not to give.
Yes.
But then once it gives,
Yes.
then that should be specifically. That is what
Not
the-
specific,
that
not
is what the
calculation the tribunal will not make. Calculation the tribunal will not
but
make.
that should be specifically mentioned.
Specifically, it is stated.
It should be made out
No,
from the
Your
words.
Lordship, paragraph F, we have read many times. Paragraph F, so far the post-award interest is concerned, it specifically says that if the payment is not made within 90 days.
But that's all right. You have said it. That goes as your thing. We are yet to come to a finding on the basis of what you say.
Yes.
We are not saying about this. We are just trying to determine what is the case of the rival party.
And so far the Morgan is concerned, there the issue was quite different.
No, that is all right. But then the explanation or the proposition which Morgan has laid down.
Yes.
What do you say about that?
No, I have already said that there is no quarrel on that. No quarrel on that.
So then you see, like,
and the arbitral tribunal has the power. See, earlier position was this, before Morgan, that if the award is silent, then only the 7B will be triggered, and claimant will be entitled to 18% interest, post-award interest, from the date of award till the date of payment. Now, the one thing was left out. The Hyder construction has not dealt the issue with regard to the power of arbitrator to award or not to award the post-award interest. The contention raised in the Morgan case was this, that the post-award interest is to be awarded on the aggregate of the principal and interest accrued on that. Total. Then the Supreme Court has said that the arbitrator has the power and discretion. They have extended because in the pre-award they have the discretion. They can award or not to award. But in 7B, they are to award. They are to award the post-award interest. And if they are silent, automatically 18% interest. Even if the award has not said.
It's okay, but then see, there is no dispute with regard to the rate of interest so far as you are concerned. Its only thing is that what is the amount awarded? That is what.
Yes.
What is the decretal amount? What is the award? That is what seems to be prime dispute between.
Yes. In fact, Your Lordship, there is no dispute as such. And I have been dragged unnecessarily at this forum, Your Lordship. There is no dispute.
That is what,
and Morgan case.
That's what we will determine, isn't it?
Morgan case does not support him at all. And he is heavily banking upon the Morgan case. And I have no quarrel with the proposition laid down in the Morgan case. But my contention is this: the Morgan case was under the different facts and circumstances, and which are not in existence in my case. In Morgan case, Your Lordship, the arbitrator has awarded the post-award interest only on the principal amount. They have specifically stated that we are awarding only on principal amount. And in the execution stage, Your Lordship, the Morgan has filed an application for claiming the post-award interest both on the interest component as well as the principal component. That application was filed during the course of the execution.
And that was allowed.
And what was the finding of the Supreme Court, Your Lordship? Will just have a look on the Morgan case once again. Page 183, 152, Your Lordship, I just have a look. What is the conclusion in the Morgan case? Your Lordship got 152?
Yes.
Paragraph 28.
Yes.
In view of the discussion above, we summarize our finding below. The judgment of the two-judge bench in SL Aurora was referred to a three-judge bench in Hyder Consulting on the question of whether post-award interest could be granted on the aggregate of the principal and the pre-award interest arrived at under Section 31(7)(a) of the Act. Both the Justice opinion in Hyder Consulting held that the arbitrator may grant post-award interest on the aggregate of the principal and the pre-award interest. The opinion did not discuss the issue of whether the arbitrator could use their discretion to award post-award interest on a part of the sum awarded under Section 31(7)(a). Your Lordship will find here, in my case, it's not a case that
it was held that the arbitrator has the
power.
Yes.
Power.
So
there is no dispute.
I think so far as this matter is concerned, you do not have conflict with regard to it.
No conflict because in my case, arbitrator has not awarded the post-award interest on a part of the sum.
See, why this issue is required to be determined here? Even we are not concerned with that also.
No, because Your Lordship, my most learned friend is pressing so much Morgan case. Even it has taken my sleep for 2 days. I could not sleep. That what is this Morgan case? And unless you read it fully, You cannot appreciate or depreciate this Morgan
Find
case.
that your counter is coming on certain thing which has not been Mr. Kumar's case. So that is what.
No, Mr. Kumar says nothing, Your Lordship.
No, he has nothing.
He says nothing other than Morgan, which is not applicable in this case.
Anyway, just complete reading. Then
And Your Lordship will see that the term principal amount nowhere mentioned either in the award
you have pointed out. You have made it.
and even in the orders passed by the commercial court. Your Lordship will just have a look on the orders which are passed by the commercial court.
Page 68.
68, no?
Yes.
Thank you, sir. 68 is the award.
Yes.
Come to Your Lordship, 69 page. This is the interim order.
What do we have to do with interim order here?
No, because Your Lordship, they are telling that we have deposited 25% and I have taken, and therefore I am bound by that.
Yes, page 69.
69. This is the order dated 20th I.
Yes, you pointed it out already. Paragraph 7 and 8, isn't it?
Yes, paragraph 7 and 8. The respondent has filed show cause to the instant misapplication. During the course of hearing, learned counsel for the award debtor submits that the award debtor is willing to deposit. The award debtor is willing to deposit 25% of the awarded amount. They are also making submission that we are ready to deposit 25% of the awarded amount, on condition that the award holder shall furnish security. That as agreed by the party, it was a consent order. That as agreed by the parties, the operation of the award dated 30/12/2016 passed by the arbitral tribunal, Shri A.K. Mitra so and so, shall remain suspended subject to the condition that the award debtor shall deposit 25% of the awarded amount.
These are not disputed. Why? This part are not disputed, is it?
No, Your Lordship, this part is not disputed, but they are telling
what is disputed is that
that 25%, the order has indicated 25% of the principal amount, whereas it is not correct. 25% is of the awarded amount, and they are interpreting it that this awarded amount is the principal amount. For that reason, and Your Lordship, the next Your Lordship may have a look to the page 72 when I withdraw the money. Paragraph 7.
Just a minute.
In view of the above.
Just a minute, Mr. Jindal. Yes, please get it.
Page 72, paragraph 7.
Yes.
In view of above, the respondent opposite party decree holder Mrs. Mega Electrical so and so is allowed to withdraw the amount of so and so as deposited by the judgment debtor, and the final amount of awarded amount including the withdrawn amount shall be subject to the outcome of the main case, commercial arbitration 14 of 2018. CEO is directed to take necessary.
That is what happens. That is the regular.
It is. Your Honor, this was a conditional payment. Even if they
that is definitely.
No, Your Lordship, just for another 5 minutes, I'll just take to the written notes which my learned friend has filed.
Yes.
They say paragraph 1.1.
Yes.
The Learned Arbitral Tribunal wide award dated 30th-12-2016 exercised its discretion and specifically directed that simple interest shall be paid at 12% only on the awarded amounts of INR 126 so and so and 21/3/2015 respectively till the date of payment of the award. They said the tribunal has exercised its discretion and awarded so much of amount with 12% interest. The next they say the Learned Arbitral Tribunal granted pre-award and post-award interest only on the awarded amount. There is no dispute that the post-award interest is not awarded. Post-award and pre-award interest both are awarded. Learned Executing Court by impugned order dated 5/2/25 at page 319 of the petition effectively modified the arbitral award by granting post-award interest on a sum of INR being aggregate of the awarded amount and the pre-award.
That is where the dispute. That is what the subject matter of dispute.
And
that is what now we are.
Yes, this is the subject matter, which I have already told that granting of interest, post-award interest on the aggregate of the principal and the interest does not tantamount to to award the interest.
See, that is also. You see, there is no problem with that. If you are if that
Hyder construction.
Yes. If that High consultation proposition is not disputed.
Not disputed.
By AG,
but their submission is their submission is otherwise.
What we have to see, by relying on Morgan's case, the submission of AG is there. That yes, it can be granted, it may be granted or may not be granted.
May not be granted.
The use of discretion by arbitrator.
Yes. No.
That is what matters.
That is what the Morgan case has supplemented the Hyder consulting case. It has not. It has laid down.
Clarified.
You are harping on one issue which is not a dispute. Actually, you are not. It is not at all disputed.
No. What is the dispute? Then there is no dispute left.
Then only you have to see what the.
If that is not the dispute, there is nothing left out.
That is okay. That is another
dispute. That is for the court to take its view. We can. So I think we're done.
No, I'm doing it. Just.
You have 5 minutes more, and then we'll have to rise, and there will be division bench.
Again.
So it has to be. That now this is how things go. So perhaps we continue with division bench yesterday till around 4:54. So keep it in mind. You know how the court is functioning.
I think you covered
every
point.
Under the impression
Yes, my friend has covered every point, my lord. Only fight of 10 minutes. I can 5 to 10 minutes, my lord. Only the issue your lordship has correctly identified in my submission, that whether the arbitral tribunal has exercised the discretion to grant interest on pre-award interest or not. For that we need to see the order of the arbitral tribunal, because the commercial court has added interest part of the awarded amount, and then commercial court has held based on reading of Hyder consulting, because probably the benefit of Morgan was not before the commercial court, because your lordship has seen that
that was not referred.
That was not referred. So therefore that benefit was not there before the commercial court, and therefore that error has crept in, because Hyder consulting, initially the entire argument of my friend was Hyder consulting mandated that if the pre-award interest is there, it has to be added into the principal amount. Automatically. Yes, that was the submission. I am grateful to my friend. Now he has digressed. He has said, yes, Morgan has clarified Hyder. So to that extent, your lordship will see the award award.
That is what,
Say-
see, after
say-
Morgan came,
Yes.
it becomes
Clarity.
important for us
Yes.
to what we award actually.
Yes, my lord. So kindly see page 61, so that's a thing which will fall for consideration of this court to interpret. The page 61, read, which one is 68? Not? 68.
Yes,
Page
basically.
68.
Yes.
Award and directive, my lord. This is the directive which we have to read, my lord.
Yes.
Foundation at location humbly unanimously award a sum of 1 crore 31 lakh 87,819 in favor of the claimant and directs that respondent shall pay the same to the claimant in full and final settlement of all disputes and claim be brought before us for adjudication under the present reference. We also award and direct the respondent shall pay simple interest at the rate of 12% on per annum on the awarded amount. My lord, kindly mark this word awarded amount because that's of significance, my lord. Awarded amount against claim number 1, 2, 3, 4, 5 and 6 and on awarded amount of 5,32,096 against claim number respectively being
Here
the
also again awarded amount.
awarded amount. So the term expression is very clear, my lord. So and so respectively being the dues of submission for claim number till the date of payment of the awarded amount by the respondent. So from the cause of action to the date of payment, my lord, till the date of payment of award by the respondent to the claimant or days of receipt of this award, this rate of simple interest of 12% would however increase to 2% per annum subject to maximum of 18% every quarter if any made by the respondent releasing the payment of awarded amount. My lord, kindly mark this again. The interest will run, simple interest will run on awarded beyond this stipulation period 90 days over. So
if you have to go by this language,
yes,
there is no question of calculating
yes
pre-award interest and including with the
yes
principal amount.
I'm grateful, and this is what the understanding of my friend is also there in the written submission, my lord. Kindly see the written submission of my friend. He has admitted to that.
The court is expressing what the court is understanding now. See,
Yes,
the
my lord.
understanding may vary.
Lordship, kindly see.
Do not take it as thing that the court has.
Yeah, I understand that much maturity I have got. Me, Lord, Your Lordship, kindly see the understanding of my friend also in his written submission. Kindly see what he says. He says same thing. He admits my case. That is why I was this. Give me the Mr. Jindal. Yes, Your Lord.
Mr. Jindal's written
Yes.
submission.
Yes, my lord.
Just a minute.
So your lordship has noticed awarded amount, interest on the awarded amount, as according to me, my lord, that this interest is on the awarded amount by the arbitral tribunal. That is my submission, my lord. Now your lordships kindly see the understanding of my friend, my lord. The two issues have been framed in the written submission. What meaning is to be assigned to the word amount awarded in the award dated 30th December?
Yes.
Rightly identified the issues. Whether the arbitral tribunal awarded the post-award interest from the date of award only on principal amount. Now the expression used found to due respect, so under INR so and so. Now lordship kindly come. Now paragraph 2.1. There is no dispute. Now we are having consensus ad idem on at least one issue. That learned arbitral tribunal, while award dated 30th December 2000, has granted simple interest of 12% within inverted comma awarded amount on 126 and 532 from so and so date till the date of payment of the awarded amount. So pre and post.
So that means that will run.
Run.
There is
It
no
will-
question of stopping.
Stopping,
and then
adding. So that will has been exercised by the arbitral tribunal. My lord, kindly see. Now, there is also not, these are admissions which I am urging in my favor, my lord, to lordship. There is also no dispute that arbitral tribunal granted pre-award, post-award interest only on awarded amount. What do I read, my lord, after reading this? Do I need to argue my case? Learned executing court wide impugn order has not modified, etc., my lord. Now 2.4, only difference between the pre-award and post-award is that awarded amount has to be paid in 90 days from the date of award. In the event of payment is not made within 90 days, date of simple interest would however increase to 2%. Now 2.5, where the change of color in the stand takes place, my lord. The term amount awarded in the award or sum awarded means aggregate. Now here, my lord, what has been stated in previous paragraphs by my learned senior counsel is that now it will get aggregated. This is what he is trying to read into the award which is not there.
But you see, it is
so.
It is only about this thing about Hyder,
Now, my lord,
and Morgan.
Now
this is
now,
two
my lord, my friend will again lose sleep because the Morgan yesterday only in the evening. Identical facts, Morgan has been referred and relied on saying that once the tribunal has awarded simple interest, there is no question of awarding compound interest. Yesterday, the evening, this judgment has come. So, now your lordship will kindly see this judgment.
I have seen the judgment. Kind pass one.
Give it to sir. Now your lordship will see. But I wanted to place Morgan first, but paucity of time, my lord, Morgan is also in my favor.
No, Morgan definitely other day you have.
Yes, placed, my lord. Yeah.
Morgan, you were just placing it to show.
Yes, my lord.
That it is a discretion.
No, there are two parts.
Inclusion will not be automatic. No, it has to be specific.
And why this discretion is there, my lord? Because it is based on reading of section 31(7)(a) of Arbitration Act.
That is what the judgment.
And 31(7)(a) says that arbitral tribunal has power to grant award interest on part sum, because the interest component will not become part of the sum automatically. If the interest, if assuming, my lord, 100 rupees is the principal amount, awarded amount, 50 rupees is interest.
So minus the proposition of Morgan.
Yes.
Minus the proposition, the judgment, impugned judgment cannot be faulted. Otherwise, if you have to simple confine to Hyder, without the clarification.
No, in Hyder, no, Morgan says that Hyder did not say that the tribunal has power to grant, because that is what Morgan clarified. Hyder has been, in my respectful submission, misread by the commercial court to mean that in all cases interest will be added. That is not the ratio of the.
That is what has been what.
That is, and that is what has been held in Morgan. That is what has held in yesterday's case, judgment pronounced. We'll continue tomorrow if permitted. So that
is there is no other option.
Yes, I'll continue tomorrow.
Just say hard hearing to continue tomorrow. We do not know. Hope we can finish it.
Hopefully, I will finish it, my lordship. Your lordship. Only 10 minutes. Only 10 minutes more.
Too much hearing on one issue may increase the confusion. You see, like.
My lord, I will. Because I am not going into other issues, my lord. This is the pure legal issue on which and this matter has been travelling to Supreme Court more often than yesterday. Also, judgment has come on this issue.
That the new judgment which you have furnished just now, you will.
Yes, my lord.
Tomorrow.
Yes, I will place that.
So we'll retain the copy.
Yes, your lordship. This is for the court's copy.
Okay. For remaining matters, we'll probably come back after division bench is over.
There's one matter that's there before my lords today.
Yes.
Item 17, Millets. This is that Flipkart matter, Millets. No, we just want somebody's come.
Items?
17 Millets, 17.
Yes.
Well, it's I'm instructed, Millets, somebody from the management has come down from Bangalore for this issue. Millets. That matter, I had made an initial submission before my lords that we'll try and sit down and try and resolve the matter. So we'll make an effort today, Millets. I've informed
you see why?
I've informed my friend as well as the.
Well, if my client is okay, I'm okay.
Yeah.
The only thing is, my lordship will appreciate. But we always wanted the matter to be settled. Lordship have seen the kind of affidavit that has been filed. Instead of making any endeavor to settle.
No. Millets, which is why I said, Millets, we'll not get into any of that. That's why I requested and they've come.
Settlement will override that.
Absolutely.
Affidavit.
We'll not, Millets, we'll not get into that affidavit or anything like that. That's why I requested, Millets, and somebody's actually flown in from Bangalore only for this issue. So we'll have a little sitting, Millets.
Shall we say that there is an effort? But you can record it.
Yes,
the name of the gentleman, I'll just give it.
It's okay, we are not recording that, but then we'll just say, yes, just try to settle it. We do not want to linger, especially Just say the Capol and senior counsel for the petitioner and Mr. Gautam Malay. Yes, where is state? State is not there. Anyway.
State is a party.
State is a party here, isn't it?
State is
Anyway,
a party.
Mr. Gautam Malay counsel. You are for the respondent number?
I am for respondent number 2, my lords. Complainant.
Submits that the contesting parties are willing to go for amicable settlement. No, is willing to work out the possibility of an amicable settlement in the matter. Hence, a prayer has been made to adjourn the matter. Today. And
We can have it after 2 weeks, Bill.
After 2 weeks.
Well, it's the interim order.
List the matter after 2 weeks. Prayer was made for adjourning the matter today, and for listing the same after 2 weeks. Something just say prayer allowed. And then interim was passed in a separate
No,
miscase.
in the miss case, Bill.
It was a miscase.
The prayer allowed. Then you say the interim order passed earlier. It will continue.
Miss case number 44 of 2025 minutes.
It is passed in the miscase.
It is passed in the
So
miss
then
case.
in the miscase you just say list along with the main case. Interim order passed earlier should continue in the miscase. Just see repeat the previous order.
I'll oblige.
Obliged.
Please see.
My lord, I will.
Something give and take, finish it. What
Absolutely.
is a small thing make a blow out of.
Well, as the petitioners are conscious of this fact, Mills, that's why they are making now, we are making a genuine effort to resolve this issue.
My lord.
Obliged.
Obliged.
Yes, for
Yes,
rest of the
Lordship.
Yes.
Lordship, I beg to mention item number 9, Lordship. Some difficulty, personal
Well,
difficulty.
9 has been lingering for a long time, my lord. This is a case where, my lord, I have served more than half of the sentence. And lordship, my lord, in fact, 2 months back it passed an
see,
order.
the last occasion you pointed out. But then just see what can be done. It is not that simply the things, because the setup we have now. But that is mean.
Absolutely, my lord. That also we have.
Yesterday also DV continued beyond court. Now, do you expect single bench to come back, sit there after?
From the bar, in fact, we want to go and meet tomorrow.
Informing you, the court could not complete yesterday's order thing.
Yes, my lord, I understand.
It becomes quite difficult.
Well, from the bar also, I think probably we'll meet Honorable Chief Justice tomorrow.
That is for you to take care.
Yes. But this one, my lord, we can have it tomorrow.
Lordship will have it
She wants it tomorrow.
Tomorrow
The reason why,
again,
my lord,
this matter will come. See, Mr. We just have it immediately on the reopening. Let it come on the news committee.
Only thing was, my lord,
Make sure that it is taken up.
the only thing was, my lord, I have served more than half the sentence. And my lord, lordship had granted me bail twice.
See, even for granting you some relief, we have to pass some kind of order, isn't it?
But I'll not argue for long, my lord, because lordship has already, on 2 occasions, my lord, granted me interim bail. I came back, my
It
lord.
is not only about your argument. The court also has to hear the other side and then pass it.
After pujas, then, my lord. Immediately after pujas.
That once
my
you
lord, with a
complete
request.
matter is completed.
My lord.
But then for a court, it is not there. The court has to see the.
Then, my lord, kindly, my lord, immediately after pujas, my lord.
Yes,
Also on the same session.
Just say on prayer made by the parties, list matter immediately after the vacation. Just make sure on the first from 6th it should be.
Much obliged.
For item 12.
Mr. Gautam, if it is secure, then you can make a prayer for upgradation also. If not on the 6th, and then we can fix it on 7th or 8th any day.
My
We
lord.
can give priority.
My lord, thank you so much.
Since he is in custody, then.
Yes, my lord. Obliged.
Item 12. Or it may be listed after 2 weeks.
It's still pending before the division bench, Your Lordship.
Item 12.
Yes.
Oh, that is POXO matter.
POXO matter,
Settlement.
yes.
And will come after 3 weeks then. Research on the prayer made by the parties list after 3 weeks. Item 12.
Item 12, yes.
Actually, would like to make a joint mention for item number 10. Lordship.
Yes.
Well, Lords, for item number 10, we have taken steps and served copies to respondent number 5 and 6 a lot.
Your Lordship, I'm appearing on behalf of the respondent number 5.
Newly implemented is one or
Newly
five.
implemented parties, Your Lordship.
I'm appearing on behalf of the respondent number 6.
How many persons have been?
Two persons have been
Who are
implemented.
they?
The complainant victims, Your Lordship. 5 and 6, the newly implemented.
They are. This is a. What is the item number here?
And item number 10, Your Lordship.
5 and 6. Okay, just say MS. Please give your name, Mr. So and so, and Miss So and so, Lorna Council, has entered a parent on behalf of the respondent number 5 and 6 respectively today. We'll have it immediately after vacation.
Yes, Your Lordship.
Yes, Lordship.
Okay. You'll be filing any objection or anything? No.
Yes, sir.
You'll be filing objection.
They will not be
We will be filing no objection for compromise, sir.
Objection for compromise or against compromise?
No objection of compromise. Yes, Your Lordship.
Anyway, then is it required to file? You'll file this thing. Okay.
Let them file
Anyway,
by way of an affidavit, Your Lordship.
that liberty will be there with you. Just say as per for by the parties. Next, as per with the parties, disseminate for hearing after 2 weeks. But then if they do not have objection, why should they file?
Yes. No, by way of an affidavit, Your Lordship. Let them begin to record the compromise deed, Your Lordship.
The respondent number 5 and 6 are at liberty to file their respective pleading with regard to prayer made by the petitioner in this revision application.
Obliged, Your Lordship.
We are not saying it objection because it may not come in the form of objection,
Yes, Your
is it?
Lordship.
Okay.
Obliged, Your Lordship.
Similar prayer for item number 14, Your Lordship.
Yes.
My Lords, I'm appearing on behalf of Mr. S. Thapa, Lordship, in this matter.
What matter is this?
POXO matter, Lordship. There's a similar matter pending before the division bench as well. Lordship.
Yes, sir. Prayer made by the parties, list of proceedings. Probably in the next, whenever those cases which are dependent on the outcome of division bench case,
Yes.
we'll pass an order saying that
The law has been laid down, Your
Till now, we have not recorded it, thinking that
Lordship.
it will be disposed at the early stage.
Lordship.
But then since it has not been done, now it is. Kindly have that number of the matter which
Lordship.
is pending before division.
Lordship.
Okay?
Yes.
So that we can say that let it be listed after disposal of that, something like that, instead of passing repeated order like this. Yes. Anything more will be there. Okay.